Good morning everyone, my name is Michelle. I hope you're doing well. Welcome to another video. It is Wednesday morning, the 29th of November, and overnight it's been a balmy -3. I think it's the coldest night we've had so far. I think that's 27 in your currency if you're in the United States of America. It was still -3 when I went out this morning, but it had warmed up by the time I got back, so yeah, positively tropical now. Alright, so today we're talking about the Delphi case again, and I want to dig a little bit deeper into these documents. The response to the second writ of mandamus and prohibition, the 27th was the deadline for responses. So we're going to look at one aspect of the response by Judge Frances Gull. We're going to look at problems with her response, and we're also going to consider what the Attorney General said. So this is the reason, according to Frances Gull, why the Supreme Court should just ignore this writ and throw it out. This court has never issued a writ to reinstate a criminal defendant's counsel whom the trial court removed for engaging in multiple acts of gross negligence, causing the trial court to conclude that the accused was not receiving competent representation. Well, according to the writ, there's a very specific reason why the Supreme Court has never issued a writ to reinstate a criminal defendant's counsel when a trial judge has removed them, because no Indiana court has ever tolerated a trial judge removing a lawyer from a case over the client's objection based on the judge's subjective belief that the lawyer is negligent or even grossly negligent. It's never occurred before. This situation is unique. It's the first of its kind because judges don't normally lose their mind. Right? It's never occurred before. That's why there's never been a writ to the Supreme Court. This is just an ultimate catch-22 for Richard Allen. It's circular. We're going round and round and round and round, like a dog chasing its tail. I mean, look at the difference, the stark difference between this ludicrous situation and the way that Judge Newman in the Alex Murdaugh saga has dealt with things. I know it's South Carolina and Indiana's not South Carolina, but still, a judge is a judge. Yesterday it was Alex Murdaugh's sentencing for his financial crimes. We knew that the plea deal had been set at 27 years, right? So the sentencing yesterday was to confirm that the judge was happy with the plea deal. He could choose to reject it if he wanted, but he didn't. He took it, and it also gave the victims and their representatives a chance to speak to Alec, and he replied, Alec, very emotional, very long-winded diatribe, just holding court literally, seemingly forever. I'm so sorry, blah blah blah. But Judge Newman, in his sentencing, called Alex Murdaugh empty and didn't buy for 1 minute the nonsense that Alec was saying. The important thing here, when Alex stood up, and bear in mind he's a convicted murderer, when Alex stood up to give his speech, he had some notes with him, and he couldn't turn the page with the cuffs he had on. And Judge Newman let the deputies take his cuffs off. He was still cuffed at the waist, but this is a convicted murderer, standing up in court, speaking at length. Judge Newman patiently listened. No shock vest, no multiple hands on him. This is a convicted murderer. Killed his wife and his son. Still afforded the respect that a human being should be afforded. I wonder what Judge Newman makes about this case. I wonder. Judge Newman has only got 34 days left to work before his retirement, so that's why he recused himself from any further proceedings. But at the end he said, job well done, guys. To everybody. A stark difference between the adversarial Judge Frances Gull. There's nothing more I can say other than she's got this massive bias. Anyway, let's see what else Frances Gull said. In disqualifying Realtor's counsel, respondent did not violate an absolute duty. Moreover, Realtor's remedies on appeal are wholly adequate. Okay, so he should appeal to a lower court, right? Appellate courts in Indiana and across the country routinely resolve issues regarding a criminal defendant's Sixth Amendment right to counsel of his choice through the ordinary appellate process. Whether Realtor's counsel withdrew or were removed, this court should deny the petition. Well, if he appealed to a lower court, here's the catch-22, that the records were so incomplete, so very incomplete. If Richard Allen had tried to appeal to the appellate court before going to the Supreme Court, there wasn't a record of what had gone down to even appeal, because the way that she disqualified the attorneys was ultimately bizarre, to which the Attorney General has kind of agreed. An original action is a limited remedy governed by strict procedural rules. Original actions are viewed with disfavour and may not be used as a substitute for appeals. Before a writ will be entertained, the relator must raise the question by written motion to the trial court. Okay, well, they did. What were the motions to reconsider? What were they? By Rosie and Baldwin, what were they? If remedy by the way of appeal is full and adequate, a party may not evoke the jurisdiction of this court under original action rules. A writ of mandamus will not issue unless the relator has a clear and unquestioned right to relief, and the respondents have failed to perform a clear, absolute and imperative duty imposed by law. Well, this is a matter of due process. She has not acted in a clear and absolute manner. She hasn't. Attorney General, very tellingly, kind of agrees here. Page 15. The lack of record prevents review of counsel's disqualification. Defence counsel's withdrawal truncated the proceedings. This is why Brad Rosie being so clear in that transcript on October 19th, because very clear he did not want to withdraw, never formally withdrew. And the present record prohibits complete review of whether the trial court's concerns justified substitution of counsel. So, record does not show a clear and absolute following of the law, does it? In chambers, prior to the October 19th hearing, the court listed reasons it felt counsel should be disqualified, that it intends to address in the hearing. The prosecutor was prepared to present evidence from the leak investigation, but this hearing did not occur because defence counsel withdrew rather than challenge the factual allegations at the time. Again, it's crucial to understand why they couldn't. It's crucial. This is the absolute heart of this matter. That the prosecutor, Slick Nick McClelland, or McVillan, as someone who I called him yesterday, Slick Nick McVillan, all right, that's going to be his new moniker, had brought a bunch of witnesses. Rosie and Baldwin truly were ambushed. They could not go out and fight that. And Rosie's words in that transcript made it incredibly clear. Respondent raised concerns that could warrant disqualification depending on the circumstances. The court's concerns raised questions regarding counsel's compliance with professional ethics and ability to provide Allen effective representation. After the state sought a gag order, counsel had ensured the court they did not intend to try the case in the media, but then issued a detailed press release challenging specific evidence that the court believed violated Professional Conduct Rule 3.6. That the court believed. Well, it wasn't after. It wasn't after. It was before. When was the gag order put in place? The 2nd of December. When was the press release by the defence? The 1st of December. The restriction on publicity commenting on specific evidence and related limits on pre-trial publicity exist to protect the defendant's right to a fair trial and the availability of an impartial jury. Well, we saw yesterday what the press release was. And here is Indiana's Professional Conduct Rule 3.6, Trial Publicity. A lawyer who is participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjunctive proceeding in the matter. Notwithstanding, a lawyer may state the claim, offence, or defence involved and accept when prohibited by law the identity of the persons involved. Okay. Information contained in a public record. So the sheriff's election, all public record. Issues with Michael Thomas, all public record. That an investigation of a matter is in progress. The scheduling or result of any step in litigation. A request for assistance in obtaining evidence and information necessary. A warning of danger concerning the behaviour of a person involved, where there is reason to believe that there exists a likelihood of substantial harm to an individual or to public interest. In a criminal case, in addition to 1 through 6, the identity, residence, occupation, and family status of the accused. If the accused has not been apprehended, information necessary to aid in apprehension. The fact, time, and place of arrest. The identity of investigating and arresting officers, agencies. Notwithstanding paragraph A, a lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from the substantial, undue, prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. So the many press conferences, the statement that Slick Nick made himself on the 22nd of November, saying that they believe they got the right man. A statement made pursuant to this paragraph shall be limited to such information as is necessary to mitigate the recent adverse publicity. So saying that they believe their client is innocent, I think, is fine. A statement referred to in paragraph A may be rebuttally presumed to have a substantial likelihood of materially prejudicing an adjunctive proceedings when it refers to that proceeding and statements relating to the character, credibility, reputation, or criminal record of a party, suspect in a criminal investigation or witness, or the identity of a witness, or the expected testimony of a party or witness. In a criminal case, a proceeding that could result in incarceration, the possibility of a plea of guilty to the offence, or the existence or contents of any confession, admission, statement given by the defendant or suspect, performance or results of any examination or test, a refusal or failure of a person to submit to examination, no, not relevant, any opinion as to guilt or innocence of a defendant or suspect in a criminal case or proceeding that could result in incarceration, information that the lawyer knows or reasonably should know likely to be inadmissible as evidence in a trial, and, if disclosed, would create a substantial risk of prejudicing an impartial trial. No. The fact that a defendant has been charged with the crime unless there is included herein a statement explaining that the charge is merely an accusation and that the defendant is presumed innocent unless proven guilty. No lawyer associated with a firm or government agency with a lawyer subject to paragraph A shall make a statement prohibited by paragraph A. So that's the entire Professional Conduct Rule 3.6. Where in that press release did they break that? Goes on to say here on page 18, the court's discretionary decision could be reviewed on appeal with a complete record. But there isn't a complete record, is there, apart from the transcript? But the limited review in this action is inappropriate. Courts have discretion to remove counsel for gross incompetence or inappropriate conduct that cannot be adequately addressed through contempt. This requires more than general concerns that counsel is not handling the case as well as they should. But the extraordinary remedy of a writ is not available where the matter is within the discretion of the trial court. This is such a case. Okay, the trial court presided by the same judge who disqualified the attorneys. It's a big fat catch-22. That's what it is. But let me know what you think in the comments below. I've been Michelle, hope you're well, and I'll see you in the next video. Bye, guys. Doodle. Oh, doodle. Doodle, doodle. Good boy. Good boy.